Please be seated. Proceedings are resumed.
Report on bills, the appropriation financial years 2018 to 2019 bill, 2017.
The appropriation financial year 2018-2019 bill 2017. Report. Honorable Minister, Finance.
Thank you, Mr. Speaker. Mr. Speaker, I have to report to the House that a bill shortly entitled the Appropriation Financial Years 2018 and 2019 Bill 2017 was considered by the Standing Finance Committee, a committee of the whole House, and the bill was passed by the committee with minor amendments.
The bill has been duly reported and is set down for third reading.
Third reading, the appropriation financial years 2018 and 2019 bill 2017.
The Honorable Minister of Finance.
Mr. Speaker, I beg to move that a bill shortly entitled the Appropriation Financial Years 2018 and 2019 Bill 2017 as amended be given a third reading and passed.
The question is that a bill shortly entitled the Appropriation Financial Years 2018 and 2019 Bill 2017 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against say no.
May we have a division, sir?
The ayes. Division, please.
Another point. The point is to see whether the opposition can vote for the bill, for the budget. No need to vote for it.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell. Honorable Julianne O'Connor Connolly.
Aye.
Honorable Dwayne Seymour.
Aye.
Honorable Roy McTaggart.
Aye.
Honorable Joseph Hugh.
Aye.
Honorable Tamara Rivers.
Aye.
Honorable Bernie Bush.
Aye.
Captain Eugene Ebanks.
Aye.
Miss Barbara Connolly.
Aye.
Mr. David White.
Aye.
Mr. Austin Harris.
Aye.
Honorable Ezra Miller.
Aye.
Mr. Alva Saku.
Aye.
Mr. Kenneth Bryan.
Aye.
Mr. Anthony Eden.
Aye, as I said before.
Mr. Christopher Saunders.
Aye.
Mr. Ard McLean.
The division is as follows. 17 ayes. One absentee. The Appropriation Financial Years 2018 and 2019 Bill 2017 has been read a third time and is passed.
First readings. The Companies Amendment Number 2 Bill 2017.
The Companies Amendment Number 2 Bill 2017, the Honorable Minister of Financial Services.
Mr. Speaker.
Sorry. The member for Georgetown Central.
Thank you, Mr. Speaker. I just want to take this opportunity to say this is the final part of the budget and my first budget as a new member of this House. And I just want to thank all the members who assisted me in that process, including members from the government and yourself, the Honorable Speaker, and members of opposition. I just want to be noted that it was an interesting experience, one that I learned from, and I appreciate all those members who assisted me in that process. Thank you.
Thank you, Honorable Member. Honorable Minister of Financial Services.
Yes, thank you, Mr. Speaker. Mr. Speaker, I assume that the first reading has been set down and is now ready to be set down for the second reading?
No,
No.
not done the first reading yet. I think you better go home early and start back tomorrow. Just started.
The Companies Amendment Number 2 Bill 2017 has been deemed to have been read the first time and is set down for the second reading.
The Limited Liability Companies Amendment Number 3 Bill 2017.
The bill has been deemed to have been read the first time and is set down for the second reading.
The Companies Management Amendment Number 2 Bill 2017.
The Companies Management Amendment Bill Number 2 Bill 2017 has been deemed to have been read the first time and is set down for the second reading.
The Insurance Amendment Bill 2017.
The bill has been deemed to have been read the first time and is set down for the second reading.
The Banks and Trust Companies Amendment Bill 2017.
The Banks and Trust Companies Amendment Bill 2017 has been deemed to have been read the first time and is set down for the second reading.
The Penal Code Amendment Number 2 Bill 2017.
The Penal Code Amendment Number 2 Bill 2017 has been deemed to have been read the first time and is set down for the second reading.
The Terrorism Amendment Bill 2017.
The Terrorism Amendment Bill 2017 has been deemed to have been read the first time and is set down for the second reading.
Suspension of Standing Order 46.1 and 2 to allow the proceeds of Crime Bill 2017 to be given a first reading.
The Honorable Attorney General.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, I beg to move the suspension of Standing Order 46.1 and subsection 2 to allow the Proceeds of Crime Bill 2017 to be given a first reading.
The question is the Standing Orders 45 and 46.1. Sorry, 46.1 and 2 be suspended. Those in favor?
Aye.
Those against? The ayes have it. Standing orders are suspended.
The Proceeds of Crime Amendment Bill 2017.
The Proceeds of Crime Amendment Bill 2017 has been given, had been read the first time and is set down for the second reading.
Second readings. The Companies Amendment Number 2 Bill 2017.
The Companies Amendment Bill Number 2 Bill 2017. The Honorable Minister of Financial Services.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Companies Amendment Number 2 Bill 2017 be given a second reading.
Is the member speaking to the bill?
Yes, Mr. Speaker, thank you. Mr. Speaker, I rise to present the bill on behalf of the government. It is a bill to clarify the law as it relates to certain aspects of the enabling legislation, that is the Companies Amendment Law 2017 that was passed earlier this year. Mr. Speaker, the Cayman Islands, as you know, signed an exchange of notes with the United Kingdom in April 2016. The exchange of notes calls for the Cayman Islands to cooperate and facilitate exchanges of beneficial ownership information on companies registered or formed in the Cayman Islands upon receipt and verification of a request from the UK law enforcement authorities. Mr. Speaker, the Companies Amendment Bill 2017, as I said, that was passed earlier this year, enabled the creation of a centralized platform through which local law enforcement agencies and competent authorities may access beneficial ownership information to facilitate the request for such information under the exchange of notes. And Mr. Speaker, I just want, for the benefit of the members of this House, but also for the listening public's perspective, this new regime is simply an enhancement to an already existing robust beneficial ownership regime, which has certainly existed in the country for at least the past 15 years. Mr. Speaker, one of the main aims of the bill before us today is to clarify certain provisions in the Amendment Bill 2017 that was passed earlier this year, including some of the provisions dealing with the exemptions. These exemptions have been discussed and consulted with the financial services industry, Mr. Speaker, and they also meet international standards. However, Mr. Speaker, now that the legislation has been in force for a while, there are certain clarifications that were identified as being necessary in order to ensure that the legislation was properly utilized. So, Mr. Speaker, the bill also seeks to specify the roles and responsibilities of corporate service providers in line with the design of the centralized platform to access the beneficial ownership information. And so, Mr. Speaker, very briefly to discuss certain aspects of the bill, it is arranged in 9 clauses. Bill 1 provides, or Clause 1 of the bill provides for a short title and commencement. Clause 2 of the bill amends Section 244 of the Companies Law to add a new definition of regulatory law for the purposes of Roman numeral Part 17A of the Companies Law. Clause 3 of the bill amends and clarifies the exemptions in Section 245 of the Companies Law. And specifically, the clause makes clear under what circumstances an entity can qualify for an exemption. Clause 4 of the bill, Mr. Speaker, inserts a new provision that requires a company exercising an exemption to declare the exemption that is being utilized. Clause 5 of the bill makes clear that the issuance of the restrictions notice under Section 256(3)(a) is subject to the limitations in Section 265 of the law. Clause 6 amends Section 261 of the Companies Law to require corporate service providers to regularly deposit beneficial ownership information received from companies as directed by the competent authority. The clause also imposes, Mr. Speaker, penalties for corporate service providers failing to comply with the provision. Clause 7 of the bill names the Anti-Corruption Commission as a body which may request a search of the centralized platform to access beneficial ownership information. Clause 8 amends Section 263 as a consequential change due to the new definition of regulatory law as it contemplated by Clause 2 of this bill that I spoke to just a moment ago. Clause 9 of the bill amends Section 280 as a consequence of the renumbering of Section 245(1 caused by Clause 3 of this bill. And so, Mr. Speaker, this concludes the presentation on the proposed bill, and I would just like to thank the Ministry staff and relevant members of the financial services industry who worked with the staff in devising and coming up with the necessary clarifications, and of course the Legislative Drafting Department for their tireless efforts in helping us to design a preparation of this bill. And I therefore commend the company's Amendment Number 2 bill to the Honourable House for passage, subject to no debate that may ensue. Thank you.
Does any other member wish to speak? The Honourable Attorney General.
Mr. Speaker, I just rise to give my support to the Honourable Minister on the bill being proposed to the House. It is part of an ongoing initiative to enhance our international cooperation regime. And I'm certainly aware of the ongoing work spoken to by the Honourable Minister. And I just would like to be on record as expressing my unequivocal support for the bill. Thank you.
Does any other member wish to speak? Does any other member wish to speak? If not, does the Honourable Mover wish to exercise a right of reply?
Mr. Speaker, just to thank the Honourable Attorney General and for the rest of the members of the Chamber for your tacit support in moving this particular bill forward. Thank you.
The question is that a bill shortly entitled the Companies Amendment Bill Number 2 Bill 2017 be given a second reading. All those in favor?
Aye.
Those against? The ayes have it.
The Limited Liability Companies Amendment Number 3 Bill 2017.
The Honourable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Limited Liability Companies Amendment Number 3 Bill 2017 be given a second reading.
The bill has been duly moved. Does the Honourable Member wish to speak thereto?
Yes, Mr. Speaker, thank you. As I did before, I rise to present this bill on behalf of the government, which is a bill to clarify the law as it relates to certain aspects of the Limited Liability Companies Amendment Law 2017, which was passed earlier this year. Mr. Speaker, as was indicated earlier, the Cayman Islands has signed this exchange of notes with the United Kingdom, which calls for the enhanced level of cooperation by the Cayman Islands in facilitating beneficial ownership information on companies registered and formed in the Cayman Islands upon receipt and verification of a request from the UK law enforcement authorities. Mr. Speaker, the Limited Liability Companies Amendment Bill 2017, which as I said, was passed earlier this year, enable the creation of this centralized platform through which the local law enforcement agencies and competent authorities may access the beneficial ownership information to facilitate this request pursuant to the exchange of notes. Mr. Speaker, one of the main aims of this bill is to clarify, as I said, certain provisions of the law now that we've had the various pieces of legislation in force for a number of months. And some of these clarifying sections deal with the exemptions under the law. And as was done with the previous bill, this bill was also discussed with the industry and consulted specifically as it relates to the proposed amendments. And the amendments do also meet international standards. However, it was determined that, as I said, clarifications were needed in order to enhance the regime to the extent that we needed to do at this time. So, Mr. Speaker, the bill also specifies to the roles and responsibilities of the corporate services providers in line with the design of the centralized platform. Mr. Speaker, the bill is arranged in 8 clauses. Clause 1 of the bill provides for a short title and commencement. Clause 2 of the bill amends Section 70 of the Limited Liabilities Companies Law to add the new definition of a regulatory law for the purposes of Part 12 of the Limited Liability Companies Law. Clause 3 of the bill amends and clarifies the exemptions in Section 71 of the Limited Liabilities Companies Law. Specifically, the clause makes clear under what circumstances an entity can qualify for an exemption. Mr. Speaker, Clause 4 of the bill inserts a new provision that requires a company exercising an exemption to declare the exemption being utilized. Clause 4 of the bill makes clear that the issuance of restrictions notice under Section 82(3)(a) is subject to the limitations in Section 91 of the law. Clause 6 amends Section 87 of the Limited Liability Companies Law to require corporate service providers to regularly deposit beneficial ownership information received from companies as directed by the competent authority. The clause also imposes penalties for corporate service providers failing to comply with the provision. Mr. Speaker, Clause 7 of the bill amends Section 89 as a consequential change due to the new definition of regulatory law as contemplated in Clause 2 of this bill. Clause 8 of the bill amends Section 106 as a consequence of the renumbering of Section 71(1) caused by Clause 3 of this bill. And so, Mr. Speaker, this concludes my presentation on the proposed bill. And once again, I'd like to thank the staff of the ministry, as well as the financial services industry working closely with us in helping to finalize this bill. And of course, the legislative drafting department for their efforts to ensure that we got this to this House in a timely fashion. And I therefore commend the Limited Liability Companies Amendment Number 3, Bill 2017, to the honorable members for passage of second reading.
Does any other member wish to speak? Does any other member wish to speak? Does the mover wish to exercise a right of reply?
Mr. Speaker, just to once again say thank you to the members of this honorable House for your tacit support.
The question is that a bill shortly entitled the Limited Liability Companies Amendment Number 3, Bill 2017, be given a second reading. All those in favor, please say aye.
Aye.
Those against say no. The ayes have it. The Limited Liability Companies Amendment Number 3, Bill 2017, has been given a second reading.
The Companies Management Amendment Number 2, Bill 2017.
The Honorable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Company Management Amendment Number 2, Bill 2017, be given a second reading.
The bill has been duly moved. Does the mover wish to speak thereto?
Yes, Mr. Speaker. Mr. Speaker, I rise to present the bill on behalf of the government, which is a bill for the law to enhance the Cayman Islands Monetary Authority's enforcement powers against licensees in certain circumstances, such as where a licensee contravenes the requirements of Part 17A of the Companies Law 2016 revision or Part 2 of the Limited Liability Companies Law 2016. Mr. Speaker, the Cayman Islands has signed these exchange of notes with the United Kingdom in 2016, and as I have explained in the two recent bills, these notes require an enhanced system of beneficial ownership information gathering and reporting to UK law enforcement authorities as it relates to verified requests received from such authorities, and the Companies Amendment number 2, Bill 2017, and the Limited Liability Companies Amendment number 3, Bill 2017, currently before this Honourable House, make clear the requirements for corporate services providers as it relates to maintenance and accessibility of beneficial ownership registers. Mr. Speaker, these corporate services providers are regulated by the Cayman Islands Monetary Authority as licensees under the Company Management Law 2003 revision. Mr. Speaker, the bill before us enhances the enforcement powers of the Cayman Islands Monetary Authority to allow the authority to take enforcement action against its licensees which breach the beneficial ownership provisions as set out in Part 17A of the Companies Law or Part 12 of the Limited Liabilities Companies Law. Mr. Speaker, this will allow the jurisdiction to have enforceable means to ensure corporate services providers comply with their requirements to maintain beneficial ownership registers for their companies for the purposes of access through the centralized platform, again, to access beneficial ownership information. And so, Mr. Speaker, this is a bill to, as I said, enhance the regime which we have already had in existence for quite some time, but it does give the Monetary Authority additional enforcement powers to ensure there is compliance. The bill also, in addition to the regulatory powers available to CIMA under the Companies Management Law, are also being enhanced to be commensurate with the regulatory powers available to CIMA under other regulatory laws. And so the amendments to this bill will bring this law in line with other regulatory laws in that regard. And so, Mr. Speaker, the bill is arranged in two clauses. Clause 1 of the bill provides for the short title, and Clause 2 of the bill amends Section 18 of the Company Management Law 2003 revision to provide for additional sanctions that the authority may take against licensees under this regulatory law. These include the power to suspend a license, to impose conditions with respect to the decisions made by the license, and several others to make the enforcement powers of this regulatory law commensurate with those other regulatory laws. Mr. Speaker, this concludes my presentation of the proposed bill, and in closing, I once again thank the ministry staff, the relevant members of the financial services industry who have weighed in on the consultation of this bill, and of course the Legislative Drafting Department for their tireless efforts with respect to the design and preparation of the bill. And I therefore commend the Companies Management Amendment number 2 Bill 2017 to the honourable members for passage.
Does any other member wish to speak? Does any other member wish to speak? Does the mover wish to exercise a right of reply?
Just to say thank you once again for the tacit support by all honourable members in this House.
The question is that a bill shortly entitled the Companies Management Amendment number 2 Bill 2017 be given a second reading. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The Companies Management Amendment number 2 Bill 2017 has been given a second reading. The
Insurance Amendment Bill 2017.
Honorable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Insurance Amendment Bill 2017 be given a second reading.
The bill has been duly moved. Does the member wish to speak thereto?
Thank you, Mr. Speaker. I rise to present this bill on behalf of the government. It is a bill for the ability to enhance the Cayman Islands Monetary Authority's enforcement powers against licensees in circumstances where a licensee contravenes the requirements of Part 17A of the Companies Law 2016 revision or Part 12 of the Limited Liabilities Companies Law 2016. Mr. Speaker, this is a part of the suite of legislation that was passed in relation to the exchange of notes which were signed with the United Kingdom in April of 2016. As I indicated before, these exchange of notes calls for the cooperation and the facilitation of exchanges of beneficial ownership on companies registered and formed in the Cayman Islands upon receipt and verification of a request from UK law enforcement authorities. The Companies Amendment Number 2 Bill 2017 and the Limited Liabilities Company Amendment Number 3 Bill 2017, currently before this Honourable House, make clear the requirements for the corporate service providers as it relates to the maintenance and accessibility of beneficial ownership registers. And again, Mr. Speaker, these are regulated by the Cayman Islands Monetary Authority. And however, some of these corporate services providers, Mr. Speaker, do not require a license under the Company Management Law 2003 revision, and they may provide corporate or company management services under licenses of other regulatory laws. And so in this case, Mr. Speaker, the bill seeks to ensure that insurance managers which provide company management or corporate services comply with the requirements of Part 17A of the Companies Law 2006 revision and Part 12 of the Limited Liabilities Companies Law 2016, as they are not required to obtain a license under the Company Management Law 2003 revision because they are regulated under their own law. So, Mr. Speaker, this bill also inserts a provision to require auditors to notify CIMA where the auditor suspects that Part 17A of the Companies Law or Part 12 of the Limited Liability Companies Law is being contravened by a licensee under this law. Additionally, the bill enhances Section 24 of the Insurance Law 2010 to allow the authority to take enforcement action against a licensee that breaches the beneficial ownership provisions as set out in Part 17A of the Companies Law or Part 12 of the Limited Liability Companies Law. Mr. Speaker, this allows the Cayman Islands as a jurisdiction to have enforceable means to ensure insurance managers that provide corporate or company management services comply with their requirements to maintain beneficial ownership registers for their companies for the purposes of access through the centralized platform. Mr. Speaker, the bill is arranged in 4 clauses. Clause 1 of the bill provides for a short title. Clause 2 of the bill amends Section 20 of the Insurance Law 2010 to require an auditor to give notice to the authority where the auditor suspects that the licensee has contravened Part 17A of the Companies Law or Part 12 of the Limited Liabilities Companies Law. Clause 6 amends Section 21 of the Insurance Law to require an insurance manager to give notice to the authority if the insurance manager suspects that a licensee who is a corporate service provider has contravened Part 17 of the Companies Law or Part 12 of the Limited Liabilities Companies Law. Clause 4 amends Section 24 to allow the authority to sanction a licensee that contravenes Part 17A of the Companies Law or Part 12 of the Limited Liability Companies Law. And so, Mr. Speaker, this concludes my presentation of the proposed bill, and I once again thank all involved, the ministry staff, members of the financial services industry, for weighing in on the consultation, as well as the legislative drafting department for their tireless efforts with respect to the design and preparation of this bill. And I therefore commend the Insurance Amendment Bill 2017 to this Honourable House for passage of second reading.
Does any other member wish to speak? Does any other member wish to speak? Does the Honourable Mover wish to exercise the right of reply?
Just to once again say thank you to all members in this Honourable House for your tacit support.
The question is that a bill shortly entitled the Insurance Amendment Bill 2017 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Insurance Amendment Bill 2017 has been given a second reading.
The Banks and Trust Companies Amendment Bill 2017.
Honourable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Banks and Trust Companies Amendment Bill 2017 be given a second reading.
The bill has been duly moved. Is the member speaking there too?
Yes, Mr. Speaker, thank you. I rise to present this bill on behalf of the government. It is a bill to enhance the Cayman Islands Monetary Authority's enforcement powers against licensees under this bill in circumstances where a licensee contravenes the requirements of Part 17A of the Companies Law 2016 revision or Part 12 of the Limited Liabilities Companies Law 2016. Mr. Speaker, this is a part of the suite of amending bills addressing the exchange of notes which was entered into by the Cayman Islands and the United Kingdom in April 2016. And as I said in all my presentations thus far, these notes call for an enhanced system of beneficial ownership collection and exchange upon receipt and verification of a request from UK law enforcement authorities. Mr. Speaker, as I've also indicated, the Companies Amendment Number 2 Bill 2017 and the Limited Liability Companies Amendment Number 3 Bill 2017, currently before this Honourable House, make clear the requirements for corporate services providers as it relates to maintenance and accessibility of beneficial ownership registers. These corporate services providers are regulated by the Cayman Islands Monetary Authority, Mr. Speaker. And some of these corporate services providers, however, do not require a license under the Company Management Law 2003 revision and may provide corporate or company management services under licenses of the other regulatory laws, such as the insurance law, which we have just discussed. Mr. Speaker, this bill seeks to ensure that licensees under the Banks and Trust Companies Law 2013 revision, which provide corporate or company management services, comply with the requirements of Part 17A of the Companies Law and Part 12 of the Limited Liability Companies Law, as they are not required to obtain a license under the Companies Management Law 2003 revision because they are licensed pursuant to the Banks and Trust Companies Law. Mr. Speaker, this bill also inserts a provision to require auditors to notify CIMA where the auditor suspects that Part 17A of the Companies Law or Part 12 of the Limited Liabilities Companies Law is being contravened by a licensee. Additionally, the bill enhances Section 18 of the Banks and Trust Companies Law 2013 revision to allow the Monetary Authority to take enforcement action against a licensee that breaches the beneficial ownership provisions as set out in Part 17A of the Companies Law or Part 12 of the Limited Liability Companies Law. Mr. Speaker, this will allow our jurisdiction to have enforceable means to ensure that banks or trust companies that provide corporate or company management services comply with their requirements to maintain beneficial registers for their companies for the purposes of accessing through the centralized platform. Mr. Speaker, the bill is arranged in 5 clauses. Clause 1 of the bill provides for a short title. Clause 2 of the bill amends Section 5 of the Banks and Trust Companies Law 2013 revision to identify the licensees to which are subject to complying to Part 17A of the Companies Law or Part 12 of the Limited Liability Companies Law. Clause 3 of the bill amends Section 13 of the Banks and Trust Companies Law to require an auditor to give notice to the authority where the auditor suspects that the licensee has contravened Part 17A of the Companies Law or Part 12 of the Limited Liabilities Companies Law. Clause 4 amends Section 18 of the Bank and Trust Companies Law 2013 revision to allow the authority to sanction a licensee that contravenes Part 17A of the Companies Law or Part 12 of the Limited Liabilities Companies Law. And, Mr. Speaker, Clause 5 amends Section 22 of the Bank and Trust Companies Law 2013 revision to empower a justice of a peace to also issue a search warrant where there is reason to believe that an offense has been committed pursuant to Part 17A of the Companies Law 2016 revision or Part 12 of the Limited Liabilities Companies Law 2016. And so, Mr. Speaker, this concludes my presentation on the proposed bill. And once again, I thank the staff of the Ministry of Financial Services, the relevant members of the financial services industry who weighed in on the consultation of this bill, and also to the Legislative Drafting Department for their tireless efforts with respect to the design and preparation and delivery of this bill. And I therefore commend the Bank and Trust Companies Amendment Bill 2017 to this Honourable House for second reading.
Does any other member wish to speak? The member for Northside.
Thank you, Mr. Speaker. Mr. Speaker, on behalf of the opposition, I just wish to offer our full support and endorsement of the package of bills just presented by the government. That is the Companies Amendment Bill, the Limited Liabilities Companies Amendment, the Companies Management Amendment Bill, the Insurance Bill, the Bank and Trust Companies Amendment Bill, because we believe that this enhances the local financial industry, and also it demonstrates our commitment to, and the government's commitment to, its continued improvement of the international image of the Cayman Islands. And I would also, Mr. Speaker, take the opportunity to invite the government to look at particularly the banking and trust company law to address some of the concerns of Caymanians that are incurring in the local commercial industry and the banking. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? The member for Georgetown Central.
Thank you, Mr. Speaker. Just to give the government and the minister my full support in making the relevant changes to enhance the industry of financial services here in the Cayman Islands. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Is the mover exercising the right of reply?
Thank you, Mr. Speaker. Just to publicly thank the Leader of the Opposition on behalf of the official opposition for your support in this suite of legislation which we have just had a second reading to, and also to the member from Georgetown Central for your support, and obviously to my members, my colleagues on the government bench. Thank you for your tacit support as well.
The question is that a bill shortly entitled the Banks and Trust Companies Amendment Bill 2017 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Banks and Trust Companies Amendment Bill 2017 has been given a second reading.
The Penal Code Amendment Number 2 Bill 2017.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill with a short title, I better read the long title. I beg to move, Mr. Speaker, that a bill entitled A Bill for a Law to Amend the Penal Code 2017 Revision to make it an offense to provide a false statement, omit a statement, or obstruct a public officer in relation to the collection of money for the purpose of government revenue and for incidental and connected purposes. Mr. Speaker, I beg to move the second reading of this bill.
The bill has been duly moved. Does the mover wish to speak thereto?
Yes, Mr. Speaker, thank you very much. Mr. Speaker, this is a very short bill, and it is along identical trajectory, if I might say so, Mr. Speaker, the raft of bills presented by the Honourable Minister a while ago as part of an ongoing efforts by this jurisdiction to continue to enhance our international reputation as it relates to us interfacing with the outside world and our financial services industry, Mr. Speaker. Mr. Speaker, members of this Honourable House are aware that the Cayman Islands in 2015 conducted a national risk assessment as a precursor to our upcoming fourth round of mutual evaluation. This is to be done by the Caribbean Financial Action Task Force, with the on-site visit starting on the 4th of December of this year. As part of that national risk assessment, Mr. Speaker, which was a sort of a diagnostic test of our framework, for our regulatory framework and the various supporting laws, some weaknesses were identified which required further tweaking of our legislation so as to make it compliant with the FATF 40 recommendations, Mr. Speaker. The upcoming evaluation will be based on the methodology for assessing what is called technical compliance with these recommendations, and it will also involve, Mr. Speaker, a test of effectiveness, again, for our anti-money laundering systems. As it relates to technical compliance, Mr. Speaker, the evaluators, when they arrived in the next 2 weeks, will closely examine all our laws, relevant laws, to determine whether they are in compliance with these 40 recommendations. Mr. Speaker, one such recommendation requires countries to ensure that is predicate offense for money laundering cover all serious crimes, all serious offenses, and that at a minimum, such predicate offenses should include a range of offenses in relation to crimes to do with direct and indirect taxes. Mr. Speaker, this bill is part of a past legislative changes which is aimed at ensuring that this and other obligations are met and that our jurisdiction's anti-money laundering and combating of the financing of terrorism framework effectively achieves the purpose for which it was established. And so, Mr. Speaker, the bill in its entirety sets out in Clause 1 what is known as the short title, and Clause 2 inserts a section 247A into the Penal Code 27 revision, which creates an offense relating to intent to defraud the government in relation to its collection of money for the purposes of general revenue. In particular, Mr. Speaker, it creates an offense where a person, among other things, willfully delivers false or fraudulent information to, or who willfully omits information required to be provided to, or willfully obstructs a person in the public service, of course, to collect money for general revenue, Mr. Speaker. That is the extent of the amendments proposed in this bill, and I certainly would wish, understandably, to commend it to honorable members of this House. Thank you.
Does any other member wish to speak? The member for Borden Town West.
Thank you, Mr. Speaker. I've been taking a look at this bill, Mr. Speaker. It has actually given me some pause in the sense that recognizing that this is a change to the penal code and general revenues for government is so broad. I mean, the thing about it, Mr. Speaker, is that I'm not even sure if this would include even customs duty if someone put the wrong custom duty on, or they fill out an immigration form, put the wrong job title, which would then basically lessen the revenues to government. It is actually quite broad, Mr. Speaker, and I'm a bit concerned with its broadness. No, well, I agree, and that's the reason. But the thing about it is that it just, I would have preferred if the language is a little bit more specific. No, I'll be the first to tell you that. I mean, anyone that looks to cheat the government should pay a price for it. But the thing about it is that where intent has always been, or where there's a mistake from the public, or sometimes it could be a genuine error. And once you have something within the penal code, it is my understanding, Mr. Speaker, that it gives someone actually a criminal record or a police record. And that's I'm a little bit fearful of, where if someone makes a mistake and it's being seen as intent and the person ended up with a criminal record for it. You know, so that's I'm a little bit concerned, Mr. Speaker, and I just wanted to make that concern be put out there, because the language in this is actually just a little bit too broad as opposed to what the Honorable Attorney General said the reason for the law was. Thank you.
Does any other member wish to speak? The member for Newlands.
Thank you, Mr. Speaker. I'll be extremely brief. Just to make the point that I see here in the amending bill, section 1, subsection 2, this law shall come into force on such date as may be appointed by order made by the cabinet, and different dates may be appointed for different provisions of this law in relation to different matters. Just to point out my objection to doing things this way, maybe the Honorable Attorney General will explain why that is in there. I don't think that will happen with this particular bill, but we've seen where this has caused issues in other legislation. So just to note that point, using the conservation law as an example, we should avoid that as much as possible. Thank you.
Does any other member wish to speak? The member for Georgetown Central.
Thank you, Mr. Speaker. I rise to agree with my colleague from Borden Town West in respect to his analysis on the wording of this bill. And just for the purposes of the committee, I want to read Section A again and what I think could possibly be interpreted, what I possibly believe can be interpreted by the honorable courts. It says, willfully makes, delivers, or causes false or fraudulent information to be made to a person employed by the public service. Now, in isolation by itself, Mr. Speaker, a person could deliver, like my colleague said, a mistake. Can the delivery of that mistake in isolation be seen as a crime? I heard the Honorable Premier said the intent, and I agree with him that they have to prove intent, but I think the wording of this, because it says or rather than and, can be seen in isolation that once you deliver it without the intent, it could be seen as a crime. And I think that leaves a very wide open space for a person to simply make a mistake on a form, like my colleague had said, in customs or in other department, and find themselves before the courts for a simple minor mistake. So in my contribution, I would ask that, and obviously the AG's wisdom as a lawyer, a very experienced one, that if the word or and would make a difference in the interpretation of the law, maybe that may be considered. And not only for him to consider that, but I rise that today, if there's any misunderstanding of what the intent of the law was, that the Hansards would show that the intent was not for mistakes, but was for persons who willfully and knowingly try to avoid paying monies and revenues due to this honorable country. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? If not, does the honorable mover wish to exercise the right of reply?
Thank you, Mr. Speaker, and thanks to all honorable members who have contributed to the debate on the bill. Very helpful. Mr. Speaker, let me just allay, well, I deal with the point raised by the Honorable Deputy Leader of the Opposition and the reason for the wording in Clause 1, which is, as he says, a wording that we often use when we do bills in this House and enact laws. Mr. Speaker, there are times when there are administrative framework to be put in place before we bring the law into force. Personnel to be appointed, regulations to be crafted, other things to be done. And it is never usually helpful to bring the law into force before all the other supporting mechanisms are in place to ensure that you can have a smooth flow. And usually when that provision is put in there, it is to make it clear that although the law is passed by the Legislative Assembly on a particular date, the usual constitutional position is that once it is assented to and gazetted, it comes into effect. That provision there mean that even though it is assented to and gazetted, it does not necessarily comes into effect until an order is made by Cabinet. And that lead time would allow for the necessary supporting work mechanism to be put in place to ensure a smooth rolling out of the law. So that's the only reason why we usually include that provision in there. But it's quite fairly standard, and it has no other sort of significance, Mr. Speaker. In respect of the points raised by the member from Boddentown and the member from Central Georgetown, Mr. Speaker, the language is cast very wide because it means exactly what it says. But it also says willfully, which means that you have to demonstrate intent, Mr. Speaker. In other words, a person would have to deliberately set out to defraud the government. And in so doing, you do so by one of these acts. Mr. Speaker, to buttress the position that I make, the law doesn't punish you necessarily for a mistake when you made an honest mistake. As a matter of fact, even in the case of murder, if you kill someone in honest belief that you're defending your own life or the life of someone else, honest belief, then you are legally not guilty of murder. Not giving any free legal advice now. Mr. Speaker, Section 8 of our Penal Code says, a person who does or omits to do an act under an honest and reasonable but mistaken belief in the existence of a state of things is not criminally responsible for the act or omission to any greater extent than if the real state of things had been such as he believed to exist. In other words, Mr. Speaker, the Penal Code makes it quite clear that we don't punish you in circumstances where it can be established that what was done was an honest mistake as to the existence of certain facts or a state of affairs. That's the law. Of course, there's a different thing about the law. If it's a mistake about the existence of the law, you're in trouble. But if it's a mistake as to fact, Mr. Speaker, then the law doesn't seek to punish you. And so I hope I've clarified that position for honorable members, Mr. Speaker. But the law makes it quite clear that it has to be willful or intentional, or deliberate, any one of those synonyms, Mr. Speaker. Thank you.
The question is that a bill shortly entitled the Penal Code Amendment Number 2 Bill 2017 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Penal Code Amendment Number 2 Bill 2017 has been given a second reading.
The Terrorism Amendment Bill 2017.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill entitled A Bill for a Law to Amend the Terrorism Law 2017 revision to ensure its compliance with international standards and for international and connected purposes be given a second reading.
The bill has been duly moved. Does the Honorable Attorney General wish to speak?
Yes,
Yes,
Mr. Speaker. Mr. Speaker, this bill too has its genesis, if I might say so, in the background outline in respect of the earlier bill, which is the Penal Code. And it is, Mr. Speaker, in preparation for the upcoming, or I dare say ongoing review, not upcoming, ongoing, because we have started in earnest already with part of the provision of the questionnaires, and the on-site inspection starts on the 4th. So it is on in earnest, Mr. Speaker. Mr. Speaker, in that regard, the FATF requires that jurisdictions implement what is called targeted financial sanctions regimes, which comply with the United Nations Security Council resolutions relating to the prevention and suppression of terrorism and terrorist financing. Those UN Security Council resolutions, Mr. Speaker, require countries to freeze without delay the funds and other assets of any persons or entity that has been designated by the United Nations Security Council, or where the governor in respect to the Cayman Islands designate a particular person as being involved in such activities. In addition to that, Mr. Speaker, the United Kingdom, in its Terrorist Asset Freezing etc. Act 2010 Overseas Territories Amendment Order 2017, requires the British Overseas Territories to consult with the Secretary of State or the Treasury Department when dealing with designations and licenses relevant to targeted financial sanctions, and to also increase certain penalties for offenses under the regime. And Mr. Speaker, we all familiar with, for example, the sanctions against North Korea, which is probably more current, and there are other sanctions against other countries. Mr. Speaker, we need to have a way to give effect to those locally. Mr. Speaker, those proposed changes to the terrorism law are aimed at strengthening the Cayman Islands framework in a way that ensures full compliance with the FATF recommendations and while bringing the law in line with the United Kingdom's international obligations and, of course, their requirements, Mr. Speaker. Accordingly, Clause 1 of the bill, Mr. Speaker, sets out this short title. Clause 2 amends Section 10 of the terrorism law in order to expand the category of offenses to which there will be extraterritorial application. In effect, Mr. Speaker, the amendment allows an offense committed outside of the Cayman Islands and under the stipulated categories to be treated, if necessary, as having been committed within the Cayman Islands. These offenses relate to the soliciting of terrorist property, the use and possession of terrorist property, and arranging for property to be used for terrorist purposes, Mr. Speaker. I think we'll readily appreciate the significance of these, given nowadays the reach of terrorists, Mr. Speaker, and their networking across various jurisdictions and various borders, international borders. Clause 3, Mr. Speaker, amends Section 12 of the terrorism law in order to extend the category of offenses that may be attributable to a body corporate, Mr. Speaker, as well as to, among other things, to directors and managers who consent to the committing of such offenses, Mr. Speaker, by the company. These offenses also relate again to the soliciting of terrorist property, the use and possession of such property, and of course arranging for property to be used for purposes of terrorism. Clause 4, this clause repeals and replaces Section 29A of the terrorism law, Mr. Speaker, in order to provide the governor with the power to propose the listing or delisting of a person by the United Nations Security Council as a person who is involved in terrorist activities. It also seeks to make freezing of funds and economic resources automatic upon the designation of a person, Mr. Speaker, by removing the requirement for direction to be given by the governor to freeze the funds and the economic resources of the designated person. In other words, Mr. Speaker, if the United Nations does a designation, it would take automatic effect if there is a person here who is designated as involved in terrorist activities, or there are funds here that are established to belong to a terrorist. So it can be done without delay. Mr. Speaker, Clause 5 amends Schedule 4A of the terrorism law in order to provide, among other things, for the following. It provides, Mr. Speaker, for the expansion of the term relevant institution to include persons engaged in relevant financial businesses, but who are not subject to anti-money laundering monitoring by the Cayman Islands Monetary Authority. Mr. Speaker, just that means that there are persons within this jurisdiction who are conducting businesses which are described as relevant financial business, but are not regulated by CIMA. They fall outside of the regulatory remit of the Cayman Islands Monetary Authority. It also speaks, Mr. Speaker, to the introduction of a definition for the terms relevant United Nations Security Council Committee and Treasury, as these terms are being introduced by the bill in Clause 5A2, Mr. Speaker. It also speaks, Mr. Speaker, to the definition of the term designated person to include persons whose named on the list include those who named on the list maintained by the relevant committees of the United Nations Security Council and those who are required by the UK Terrorist Asset Freezing Order 2017, as I mentioned earlier. Mr. Speaker, it also speaks to the power of the governor to propose through the Foreign and Commonwealth Office the listing of a person by the relevant committees of the UN Security Council as a designated person, and, of course, the delisting of such person where there is no reason to believe that the person is any longer, it has been established the person is not involved in terrorist activities. The governor is also provided with the power to establish procedures relating to the delisting of persons who no longer meet the criteria for designation as a terrorist. Mr. Speaker, the bill also empowers the collection of information in order to identify persons who meet the criteria for designation under Clause 5F2 that is information in order to be able to make an informed designation of a person as a terrorist. Mr. Speaker, in the designation or delisting, the bill provides for the governor to consult with the Secretary of State when dealing with such designations, and to consult with the HMG Treasury when dealing with licenses for such financial resources. Mr. Speaker, the bill also addresses the requirement for the Financial Reporting Authority, the FRA, to communicate designations as soon as reasonably practicable after the designations has been made to the relevant institutions, as well as to any public body or self-regulatory body assigned by Cabinet under Section 49 of the Proceeds of Crime Law. Mr. Speaker, what that means is that the Financial Reporting Authority will have the duty to make it quite clear to the relevant service providers and public bodies that someone has been designated either terrorist or the property has been designated a terrorist property, and therefore the usual freezing and so on took place. And it speaks about body assigned by Cabinet under Section 49. The Cabinet now has the power under the Proceeds of Crime Law to designate, like the DCI, Department of Commerce and Investment, as a regulatory or supervisory body for like persons involved in precious stones and metals and jewelers if they're involved in money laundering activities, or for the purpose of money laundering activities. So, Mr. Speaker, there is expansion of instances in which a person is required to freeze without delay and without giving prior notice to the owner of the funds, those funds and the economic resources of the designated person. The amendment, Mr. Speaker, also seeks to ensure, among other things, that funds that are wholly or jointly owned by a designated person are funds derived or generated from funds or economic resources owned or controlled by a designated person are also caught, Mr. Speaker. So those would be subject to a freezing order as well. Mr. Speaker, the bill also speaks to an increase in the penalties and summary conviction for offences under Schedule 4A and Clause 5U. And of course, Mr. Speaker, as to be expected, the bill deals with savings and transitional provision. And so, Mr. Speaker, it's quite a mouthful, but the fact is that it is a further attempt, I might say, at shoring up the Cayman Islands framework as it relates to targeted sanctions imposed by the United Nations Security Council, where persons are involved or engaged in terrorist activities, and there's a need to move with dispatch in immobilizing their properties and designating them and make that known to prevent them from conducting their affairs in or through or from this jurisdiction. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Is the Honorable Attorney General intending to reply?
Thank you, Mr. Speaker. I understand that we wish to thank members, honorable members, for their support of the measures as outlined in the bill. Thank you.
The question is that a bill shortly entitled the Terrorism Amendment Bill 2017 be given a second reading. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Terrorism Amendment Bill 2017 has been given a second reading.
the Proceeds of Crime Amendment Bill 2017.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, this is the final bill in this regard, the Proceeds of Crime Amendment Bill, and I seek leave of the House to move for the second reading. It is a bill, Mr. Speaker, entitled A Bill for Law to Amend the Proceeds of Crime Law 2017 revision to ensure that the law complies with the international best practices and for incidental and connected purposes. You can proceed, Mr. Speaker. You can proceed.
Proceed.
Thank you. Mr. Speaker, the basis for this bill is similar to those outlined in the previous two bills, and I intend to run through the provisions of this bill, Mr. Speaker, and I intend to have a little more to say in respect of this particular bill and some of the overall initiatives that we're pursuing. Mr. Speaker, the bill the bill in clause 1, of course, sets out the short title. Clause 2, Mr. Speaker, seeks to amend Section 2 of the Proceeds of Crime Law by inserting definitions for the terms competent authorities, financial year, and insurance business, Mr. Speaker. The first two definitions are terms being introduced by further amendments contained in this bill and just require definition, while the latter term was previously introduced but was left undefined, Mr. Speaker. So, for example, competent authorities now means a public body in the island charged with responsibility for combating money laundering and the terrorist financing, including the Financial Reporting Authority and any authority charged with the responsibility for investigating and prosecuting money laundering and associated predicate offenses and terrorist financing, and for seizing or freezing and confiscating criminal assets. Financial year, Mr. Speaker, now means in relation to the Financial Reporting Authority, the year ending on the 31st of December. This is to bring that in line with other amendments that we have done in this House to change the financial year, Mr. Speaker. And insurance business mean business of any of the classes of business specified in the schedule to the Anti-Money Laundering Regulations 2017. Mr. Speaker, there is a committee stage amendment that has been circulated in respect of this bill and which we will discuss at the relevant time. Mr. Speaker, Clause 3 seeks to amend Section 4 of the Proceeds of Crime Law so as to permit the Financial Reporting Authority to disseminate information and results of any analysis it has conducted, to be able to disseminate this to the Cayman Islands Monetary Authority where necessary, and also to law enforcement agencies and to any other relevant body, public body, to which has been assigned regulatory powers under Section 4.9 of the Proceeds of Crime Law. I mentioned earlier on, Mr. Speaker, for example, the DCI, Department of Commerce and Investment. They would have supervisory powers or active supervisory role for persons involved in precious metals and precious stone, jewelry, real estate, and so on. Mr. Speaker, the bill also in Clause 4 amends Section 11 of the law so as to change the date for the submission of the FRA annual report from the 30th of September of each year to now read no later than 3 months after the date of the end of the financial year. Clause 5, Mr. Speaker, amends Section 114 of the Proceeds of Crime Law to place an obligation on the collector of customs to report cash seizures under this section, Mr. Speaker, to the Financial Reporting Authority. So where the collector of customs sees cash coming across the border in excess of certain amount, and for which, of course, there is no explanation, then he has a duty to report that to the Financial Reporting Authority. Clauses 6 and 7, Mr. Speaker, amends sections 136 and 137 of the law so that the court may consider guidance issued by any public body or self-regulatory body to which the Cabinet has assigned the responsibility for monitoring AML compliance. And in addition to that, in addition to those guidance issued by CIMA, when determining, Mr. Speaker, when the court is determining matters relating to the commission of an offense or failure to disclose suspicious activity report to a nominated officer. Mr. Speaker, that means that if someone's committed an offense and one of these regulatory offenses, and it is established that CIMA has issued guidelines or guidance on how these activities should be carried out, and it is determined during the trial that these guidance were ignored, then it is open to the court to take into account the fact that there were guidance issued by CIMA and our DCI, and these were ignored by the body or the person who is alleged to have transgressed. And so it could very well be an aggravating feature, Mr. Speaker, in disposing of the matter. The court is entitled to take that into account. Clause 8, Mr. Speaker, amends Section 138 of the law to allow the Financial Reporting Authority, in circumstances where it has cause to suspect that criminal conduct has been committed, to make disclosures not only to the Cayman Islands Monetary Authority and the department responsible for international tax matters, but also to any other public body, again, like DCI, Mr. Speaker. So it would now put that, sorry, not put that responsibility, it would now enable Financial Reporting Authority to make a similar report to the Department of Commerce and Investment in respect of one of its licensees. Mr. Speaker, Clause 9 of the bill seeks to amend Section 144 of the Principal Law to stipulate the issues to be considered when a determination is to be made as to whether a person is the beneficiary of the proceeds of criminal conduct. It stipulates, Mr. Speaker, for example, that when making that determination, the court that is, when making that determination, it is immaterial or irrelevant for that matter whether or not the person was provided with money or goods or services in order to enable them to commit that offense. What is relevant, Mr. Speaker, is to show that he was a beneficiary of the crime, whether by getting a proceed or something. Mr. Speaker, Clause 10 is a minor amendment to specify a cross-reference to Section 45(2) to 7 instead of what is now there, which is Section 45. So it is a minor error being corrected there. So it should read Section 45(2) to subsection 7 instead of Section 45. And this, Mr. Speaker, has the effect of allowing the grant of external restraint orders without the need for an investigation to have been commenced within the Cayman Islands. Simply put, Mr. Speaker, whenever a request is made from abroad for a restraint order, that is to freeze someone's asset that is in the Cayman Islands because the person is being investigated abroad for a criminal offense, the law as it currently stands seems to suggest that for the restraint order to be granted by the court, the prosecutor would need to demonstrate that the person has committed an offense here as well, and that an investigation is happening here. that is inconsistent with our obligations under the international obligation, sorry. So once we're satisfied that an offense is being investigated in the foreign country, and it is established that there are assets here, we ought to be able to carry out that restraint order once we're satisfied as to the genuineness of the investigation, without having to require that an investigation be started locally in order to trigger the external restraint orders. Final, Mr. Speaker, on this section, Clause 11 amends paragraph 11 of Schedule 6 by inserting after the word management the word and. Mr. Speaker, this is a minor change so that the section would now read individual and collective portfolio management advice. It would now read, individual and collective portfolio management and advice. The amendment remedies, Mr. Speaker, what was an inadvertent omission of the word and. Mr. Speaker, allow me to touch briefly on the related issue, Mr. Speaker, in the context of what we're discussing here. You would have heard the 5 bills moved by the Honorable Minister for Financial Services, the 3 that have been done by me so far, which represents a continuum, if I might put it that way, over the last 2 years, and certainly way back before then. We have consistently, this House have consistently made amendments to our laws in order to enhance our reputation and to assist with our international cooperation regime, Mr. Speaker. And we saw recently this issue, Mr. Speaker, the theft and the unauthorized disclosure of persons' private information in circumstances where these investors have obviously followed the relevant laws in ordering their legitimate investments in other countries. Mr. Speaker, Cayman, like all other civilized democracies, operate on the basis of the rule of law. Operate on the basis of the rule of law. In that regard, Mr. Speaker, the Cayman Constitution provides in Section 9 of the Bill of Rights that every person should enjoy respect for their private and family life. Of course, there are certain well-recognized, documented exceptions created by the Constitution itself, Mr. Speaker, and none of which are relevant in the context of what has transpired with these theft, Mr. Speaker. That's what they are, theft. Mr. Speaker, the significance of this is that in the publication of the and the commentaries on the infamous Paradise Papers, it has been repeatedly stated, and correctly so, that nothing unlawful has been revealed. Mr. Speaker, that is, that there was nothing unlawful on the part of the investors, the service providers, or indeed the jurisdictions involved. It therefore begs the question, Mr. Speaker, what was the aim of this unwarranted invasion of privacy of others? Whatever the aims, Mr. Speaker, I think we can all agree that it was not a legitimate aim. Mr. Speaker, the issue of country-to-country cooperation in the enforcement of each other's tax laws has a very long history, and which has seen the evolution of various protocols over decades to try and bring about a mutually acceptable framework, Mr. Speaker. Indeed, we only need to cast our minds back to the universally accepted position, as back some 62 years or more, even further back, from the 1700s, I think, where the common law emphatically stated then that a state has no legal obligation to enforce the tax laws of another state, and that the only exception, Mr. Speaker, to this rule, as authoritatively stated by the 1955 UK House of Lords case of the government of India and Taylor was that if there is in place a treaty between the two countries whereby they agree to assist each other in the enforcement of their tax laws. Accordingly, Mr. Speaker, the way that countries seek cooperation with each other in the enforcement of tax laws, their respective tax laws, is by way of treaties, conventions, or other similar agreements, whether these agreements are bilateral or multilateral. In other words, Mr. Speaker, by way of diplomatic accords, not through threats, not wars, and certainly not in seeking to name and shame another country. Mr. Speaker, in the context of the Cayman Islands, this is of particular significance. It is of significance, Mr. Speaker, because as we are all well aware, Cayman Islands did not set out to rewrite its tax laws so as to entice businesses away from other competitor jurisdictions for financial services business. No, Mr. Speaker. The position is and has always been that Cayman Islands has never had direct taxes. It is still a jurisdiction based on indirect taxes. But, Mr. Speaker, the lack of domestic tax base has not prevented the Cayman Islands from entering into numerous tax information exchange treaties, conventions, and other similar agreements, bilateral and multilateral, with numerous countries throughout the world. These, Mr. Speaker, include with the European Union, as you all are aware, starting with the European Union Savings Directives, agreements, Mr. Speaker, with the United States, one of the first countries which we signed tax agreement in 2001, and other major countries in Asia, Central, North, and South America, in order to cooperate with them, Mr. Speaker, in the enforcement of their respective tax laws, and to allow, as allowed by our domestic laws, the respective domestic laws. Mr. Speaker, as you're aware, we have such agreements with Japan, Australia, Singapore, all of these major countries. So we have been engaging, Mr. Speaker. These diplomatic engagements by Cayman started decades ago and continue as I stand on my feet here today. Mr. Speaker, Cayman is a party to more than 30 tax information exchange agreements, including with the European countries. We're a party to the OECD Common Reporting Standards Initiatives on Taxes, including being a party to the Convention on Mutual Administrative Assistance in Tax Matters, which has been developed by the OECD and the Council of Europe, and which, as you know, Mr. Speaker, are protocols put in place to facilitate the global automatic exchange of financial accounts and tax matters. Mr. Speaker, we shouldn't forget the USA FATCA and a similar arrangement with the United Kingdom, which is a forerunner, of course, to the Common Reporting Standards, which is by itself a byproduct of the Mutual Administrative Assistance Convention, and to which Cayman Islands is a party. Mr. Speaker, another significance of these initiatives mentioned by me is that, as you are aware, when the discussion started way back then, and the first sets of agreement were entered into, it was on the understanding, Mr. Speaker, that assistance would have been by way of request. So we'd only share information upon request. However, Mr. Speaker, since then, Cayman is one of the many, many countries which have agreed to automatic exchange of such information. And so, Mr. Speaker, Cayman no longer sits around idly and await a request to share such information. It is now done on an automatic basis, and which, Mr. Speaker, is further evidence of our ongoing cooperation with the world to fight tax crime. Mr. Speaker, the OECD Global Forum, which, as you know, is a global standard setter for transparency and the sharing of information on tax matters, has consistently confirmed that there is no secrecy laws in the Cayman Islands that prevents the exchange of tax information for regulatory and or law enforcement purposes. Our last report, Mr. Speaker, and the second round of reviews was published this year, August 2017, a couple of months ago. It has confirmed, Mr. Speaker, Cayman's overall rating of largely compliant and transparency on tax matters. Mr. Speaker, it reads, with your permission, at page 89. Mr. Speaker, permit me with your permission to read page 89, paragraph 291. The heading is Secrecy Provisions. Mr. Speaker, this is the latest OECD Global Forum report on the Cayman Islands, August 2017.
Sorry, you were saying
Page 89.
Page
89.
Page 89.
Yes. Paragraph 291. Thank you. Secrecy provision. Mr. Speaker, the report, and I quote, it says, Mr. Speaker, secrecy provisions in a jurisdiction should not impede the exchange of information, and appropriate exceptions should be allowed where information is sought in connection with a request for information under an exchange of information agreement. Goes on, Mr. Speaker, quite instructively. It says, no secrecy provisions exist under Cayman Islands law to prohibit or restrict the disclosure to tax authorities of accounting, ownership, and identity information for information exchange purposes, for exchange of information purposes. There are no specific bank secrecy rules in the Cayman Islands. Confidentiality of any form of information is governed by the general common law obligations of confidentiality. Further, the Confidentiality Information Disclosure Law 2016, which replaced the Confidential Relationship Preservation Law 2009 revision in 2016, like its predecessor, provides gateway for the provision of information which would otherwise be regarded as confidential. In any event, all confidential requirements are overridden by Section 8, subsection 6b, and subsections 18 and sections 18 and 19 of the Tax Information Authority Law, where information is required to be produced for exchange of information purposes. This allows the Cayman Islands Tax Information Authority to access and then to exchange information notwithstanding any common law or statutory rules on confidentiality, and without invoking any gateway provisions. In addition, it goes on, Mr. Speaker, any offense or liability to civil claims which would otherwise arise against the holder of information as a result of producing that information is expressly excluded by Section 18 of the Tax Information Authority Law. Mr. Speaker, overleaf, paragraph 294, bank secrecy. It says the 2013 report noted that there are no limitations on the ability of the Cayman Islands Tax Information Authority to obtain information held by a bank or other financial institutions for the purpose of responding to an exchange of information request and a means of accessing information via notice to produce the same as for all other type of information. This continued to be the case, as noted above. There were no issues in accessing banking information over the review period. And finally, Mr. Speaker, in that regard, paragraph 297, the Cayman Islands authorities and their exchange of information partners have indicated that no cases have occurred in practice where information could not be obtained because the holder of the information, lawfully or not, made a secrecy claim. Mr. Speaker, so this is not just the Cayman Islands saying that. Our information exchange partners abroad, people who request information from us, has confirmed that no cases have occurred in practice where information could not be obtained because anybody has invoked any secrecy provision. Mr. Speaker, that is the clearest validation of the kind of framework that we have in the Cayman Islands. This is the OECD Global Forum report. This is standard setting body, not a Cayman Islands entity. This is the world standard setting body, Mr. Speaker. And so, Mr. Speaker, it is clear that the ongoing diplomatic engagements are working. And therefore, it is most unfortunate, indeed very disappointing, to see the recent threats by those who still have the diplomatic avenues open to them to now try and smear this jurisdiction, Mr. Speaker. It is even more disappointing that there is a subterfuge being employed by those who think that it is okay to steal and to publish people's private investments information to the rest of the world. Shameful. Such an approach, Mr. Speaker, is not only unhelpful, it is counterproductive. We are known for our stellar record of cooperation as confirmed by the OECD, and as a jurisdiction, we will continue to do so. Mr. Speaker, the government has been pounding the pavements to explain our framework and to pledge our cooperation within the context of a domestic law. And so, Mr. Speaker, we strongly urge those involved to desist from these counterproductive conducts and to instead continue the constructive and obviously productive dialogue to which we have all grown accustomed. I thank you, Mr. Speaker.
Does any other member wish to speak? The member from Georgetown Central.
Thank you, Mr. Speaker. I just had a concern in respect to the legislation and the ability to freeze persons' assets without a timeline of how long it can be freezed for. By all means, nobody wants to handcuff the legislation from doing what its intended purpose is. But sometimes we have cases where persons are, I apologize, Mr. Speaker, because this mic is too low. I'm 6'2", and I've asked for the mic to be increased up a little higher. So I'm constantly having to get down low to speak to you.
We can hear you.
My concern was whether or not the Attorney General's office have had concerns in respect to or considered whether or not a timeline on specifics, or is that not something that is the norm in other jurisdictions in respects to freezing of proceeds for this kind of element of terrorism?
Does any other member wish to speak? Does any other member wish to speak? The Minister of Financial Services?
Yes, Mr. Speaker. Mr. Speaker, I rise to make a very short contribution because I think the Honourable Attorney General has done a stellar job in outlining and reinforcing all of the efforts that the Cayman Islands have done, what we have done, what we continue to do in the face of the threats to the jurisdiction, but also to ensure that we are not just talking the talk when it comes to global cooperation in fighting anti-money laundering and the financing of terrorism, fighting anti-corruption, fighting tax evasion, and generally demonstrating why we are and why we should continue to be a leader in the global financial services industry. Mr. Speaker, as I said, the Honorable Attorney General gave us a good overview of some of the very early efforts the country has taken from the first tax information agreement with the US, as he referred, in 2001. But Mr. Speaker, our efforts to tackle these ills, these global ills which plague many jurisdictions, and the fight needs to be a global fight. And as such, we have demonstrated our willingness to be active participants in helping to shape these standards of what are considered acceptable with respect to exchange of information. The Honorable Attorney General spoke about the various parties to which we now exchange this information for tax purposes from the early turn of the century to where we are now. We have over 110, Mr. Speaker, 110 exchange of information for tax purposes, countries that we exchange on request, but we also, as the Attorney General indicated, we have now moved to adopting the common reporting standard as it relates to the automatic exchange of requests, and we have just as many partners in that process as well. I think it's also important to underscore what was said with respect to the lack of secrecy laws that exist on our books. And Mr. Speaker, it's unfortunate because when people don't understand or intentionally misrepresent, depending on their perspective, what we do in Cayman, it is often with the claim of things being done shrouded in secrecy. But as the Honorable Attorney General has so poignantly pointed out, don't just take our word for it. Refer to the organization, the OECD Global Forum, who is seen as the global standard setters for these initiatives in their recent report on information for tax purposes. They have reinforced that point. And so, Mr. Speaker, gone are the days of the firm. And that's one thing we have to say about the effects of Hollywood. They live on long after reality has determined otherwise. But it's unfortunate, Mr. Speaker. Mr. Speaker, with your permission, I would like to table in this honorable House just so members will have copies of a pictogram that just gives an overview of some of the key initiatives that this country has been engaged with since the 1960s up until present, 2017. And Mr. Speaker, obviously, this doesn't capture what we're doing here today with respect to the amendments and the changes that we've made to further enhance our regime. But this, Mr. Speaker, should give everybody in this honorable House a clear understanding and ammunition to be able to help to inform. Because, Mr. Speaker, we have to do better as a country. We have to do better as an industry to help people not just across the pond, but even our own people, to help from a domestic perspective to get the message out, as well as an international perspective, so people really understand who we are and what we do versus what we are not. We're not a tax haven. We do not have the secrecy laws, as I said, was expounded upon by the Honorable Attorney General, as confirmed by the OECD themselves in their latest 2017 review of our jurisdiction. We do not have the anonymous numbered accounts that would facilitate the kinds of mischief, I should say, being very kind. We do not have the double taxation agreements that would facilitate the abuse of such tax agreements in the efforts to promote tax evasion or aggressive tax avoidance. So, Mr. Speaker, there are a number of things that we have been doing, we continue to do, and we're committed to continue doing to ensure that we do our part to see that the global financial services industry thrives for the benefit of the global economy. And we have done so from the very beginning. And as, again, just wanting to underscore what the Honorable Attorney General has said, because I think it's something people need to understand. We have not designed our tax system in a way to try to aggressively market the jurisdiction in a way that creates harmful taxation to other jurisdictions. We have never had corporate tax. We have never had the income tax, but we have a very robust tax system of customs duties, stamp duties, licensing fees, business tariffs, that, Mr. Speaker, generally equates to about roughly 25% of GDP. So this is very, very comparable to other jurisdictions that may have the corporate taxation, the income taxation. So because our tax system is different, is often misunderstood. And those are just some of the key, not just messages, but understanding of the jurisdiction, the kinds of value that we add. And Mr. Speaker, the government, as the Honorable Attorney General has said, has, long before I took on this particular role, I know certainly we have continued to do so. We didn't just hit the ground running. I think we got off to a flying start when it comes to continuing the engagement on the international level to ensure that we help people to understand who we are, what we've done, but yet we do know that there are many, many forces that are lining up to try to ensure that that message, that true message, is somehow lost in the rhetoric. And I've often said this on the radio, Mr. Speaker. I'm not sure if I had the opportunity to say it in this House before, but it reminds me of an adage where you say, why let the truth get in the way of a good story? And unfortunately, Mr. Speaker, it just means that we have to ensure that the truth of what we do, our regulatory regime, the robustness of our cooperation and efforts to engage to ensure that we are partners in the fight of financial crime is not lost when the stories are created. So with that, Mr. Speaker, I will, with your permission, table this graph. This is a work in progress, Mr. Speaker, because as I said, every time we make a change to make our system even more robust, even more cooperative, even more innovative in the fight in financial crime, this we expect to change. So this is a snapshot but it'll just give an overview of all of the work that we have done for many, many decades to ensure that Cayman continues to do our part and why we have earned our place in the global financial services industry as an international financial center. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does Honorable the Premier?
Thank you, Mr. Speaker. Mr. Speaker, I wish to make a short contribution to the debate on this important bill, and I wish to endorse what has been said by the Honorable Attorney General and the Minister for Financial Services with respect to this ongoing issue of seeking to persuade the world that the Cayman Islands is a legitimate jurisdiction for the conduct of financial services business. Mr. Speaker, I think I've said this in this House before, but it was actually a situation similar to the one that we now face with the imminent promulgation of the EU's latest blacklist scheduled for the 5th of December that drove me or lured me into politics 17 years ago, more than 17 years ago. And, Mr. Speaker, one of the great ironies is that these years hence, the issues are still the same. Notwithstanding the tremendous amount of work Cayman has done and other jurisdictions to be part of the global solution to fighting tax crime and money laundering and terrorism financing and a range of financial services, financial crime that exists in this big bad world. Mr. Speaker, the so-called Paradise Papers, to which the Honorable Attorney General referred, as I said much earlier in this meeting, have been published or were published at the time they were as a deliberate and powerful effort to influence the views of the EU ECOFIN ministers, the economic and finance ministers of the 28 member states of the European Union, as they consider the work of the Code of Conduct Group, which has been going through the affairs of various jurisdictions across the world who conduct some form or other of financial services business, to determine whether or not these jurisdictions are non-cooperative with respect to the fight against global tax, crime, and money laundering and terrorism financing. And so, Mr. Speaker, what we've had since the theft of the confidential information for which otherwise reputable organizations appear to have paid huge amounts of money for the proceeds of crime. But, Mr. Speaker, ironically, no mention is made of the fact that the information, the confidential information, all of which, by their own admission, represents legally conducted business and business affairs. No discussion is made of this huge criminal offense, a set of offenses which have not just been sanctioned apparently by members of the international media, but they also appear to be part and parcel of what is an ongoing crime or set of crimes. But anyhow, that aside, Mr. Speaker, here is where we are as a jurisdiction. I'm not going to try from memory to sit and recite the long list of international agreements, conventions, protocols to which the Cayman is a signatory and participant, and in many instances, an early adopter. But I say without reservation that Cayman is at the leading edge when it comes to the fight against international financial crime, money laundering, terrorism financing, and tax evasion, tax avoidance, or tax crime. We are out front. We are in a better position than the United Kingdom, than of most of the European Union countries. But here we are, having to fight to persuade ECOFIN ministers that we ought not to be on a blacklist. A blacklist which I am willing to wager just about anything, save my soul, will never include some of the greatest offenders, some of the least transparent and cooperative jurisdictions in the world when it comes to tax matters and when it comes to money laundering issues, like the mighty United States of America and China. You can walk into any bank in Miami, let's not go too far afield, and open an account in 15 minutes with whatever money you have in your pocket and your driver's license. Try to open an account in Cayman if you think you're bad. Try, Mr. Speaker, to find out anything about the beneficial ownership of any company registered in the state of Delaware. But, Mr. Speaker, those countries, that state runs no risk of appearing on any blacklist promulgated by the European Union. Mr. Speaker, as I started to say, here's where we're at as a jurisdiction. We have to start asking ourselves, what is the point of the expense and the trouble that we put ourselves and customers and clients of these islands to be part of the global solution? If the quid pro quo for that is one threat after another of appearing on a blacklist somewhere. We are at a stage now where no one seriously questions the transparency of the jurisdiction and our international cooperation with respect to the exchange of, well, it's not really exchange, it's a one-way trade of tax information. So now the challenge, Mr. Speaker, is that although everything is done lawfully, and the latest exposés and commentary about the Paradise Papers, they've been very careful, perhaps because Her Majesty the Queen, part of her estate has been involved in some of the investments in Cayman and other funds. Perhaps that's why there's certain deference about that. But they've been careful to say there's no illegality involved. And they now claim it's a moral issue. Of all of the places in the world to talk about morality, the European Union. Anyhow, that's another story. But it is now a moral issue. And so it is now immoral for legitimate countries and investors to use tax neutral or low tax jurisdictions as part of their legitimate business arrangements. So that it is somehow wrong now for investors from all over the world who reside in jurisdictions with varying tax rules to decide to invest in a Cayman registered fund. A fund set up because of Cayman's tax neutral status. And so there would be no tax payable by the fund in Cayman as the result of capital gains or otherwise. But tax remains payable by each investor in that fund on any profit they derive in their home countries. So where is Cayman? How is Cayman and the jurisdiction and the rules that we have, tax rules that we have, how is that somehow negatively impacting any other country in the world? How are we somehow depriving the United Kingdom of any profit the Queen's estate might make as a result of investments made by this fund? Her estate is required to pay tax in the UK on any profits that are so derived. How is it, Mr. Speaker, wrong and immoral for Airbus, a EU company, entity, to purchase an aircraft using a special SPV in Cayman as a vehicle by which to obtain the necessary financing to do the transaction, so that there is no complications. They do it so there are no complications with respect to the tax rules that differ between Airbus's jurisdiction and the jurisdiction of the financier. But whatever rules apply with respect to interest earned on the loan or on the asset that is acquired by Airbus are payable by the respective entities in their home jurisdictions. What's immoral and wrong about that? But, Mr. Speaker, you have so many of these people who either are blinded by whatever cause it is. They think that somehow they've been persuaded that financial services jurisdictions which are offshore, like the Cayman Islands, are somehow facilitating the highway robbery and theft of assets from developing countries in Africa and around the world, and are responsible for the poverty that exists in some of these countries. Because if taxes if we didn't exist, if jurisdictions like ours didn't exist, they would be tax payable, and somehow that would make the lives of everybody in the world that much better. They do not recognize, seemingly, Mr. Speaker, that places like the Cayman Islands, which have evolved without any form of direct taxation, through their ingenuity and the absence of overwhelming taxation, have been able to create systems and services which actually facilitate the flow of global capital, thus increasing what is paid in terms of tax, because the more profit, the better the profit of the organizations and entities that do invest in Cayman funds, as an example, the more tax they have to pay in their home jurisdictions. And so, Mr. Speaker, we have been engaged, some of it quietly, for quite some time, because it never ceases. Well, as I started to say, I was first exposed to this in a serious way when I was president of the Bar Association in 1998. That's when I started to get seriously engaged in these issues. That was not yesterday. But, Mr. Speaker, we are at a point now. We've gone full circle. So we're back to this. I spoke about that particular issue, about the requirement of what they're calling substantial presence. In other words, if the entity which is registered or in the Cayman Islands, whether it's a company or whatever, does not have a substantial presence, and we don't know quite what that means because it's not defined anywhere. Perhaps, presumably, they mean a big building, lots of employees that are being paid. That somehow that renders their presence in the jurisdiction as illegitimate. That they're just there as a nameplate and serve no other purpose, so therefore there has to be, this is evidence of some kind of tax dodge. When in reality, Mr. Speaker, the special purpose vehicles, the SPVs, which I referred to earlier, are often created for a particular transaction, like the sale of an aircraft to Airbus. And their purpose falls away once the transaction has been completed. But we are having, Mr. Speaker, the people involved in this are much smarter than me, I believe. This is what they study, this is what they do. I cannot believe that they don't understand these things. And I am driven inexorably to the conclusion that the purpose is not anything else beside trying to run jurisdictions like the Cayman Islands out of the financial services provision business. And all the rest of it is just the means to get there. It's been a quarter of a century at least of sustained effort on their part. As I said, I first came into this in 1998, and they were hammering from before that. So, Mr. Speaker, only about 8% of the investment in Cayman funds comes from Europe. The two big financial powerhouses in Europe, one is already outside the EU, that's Switzerland, and Britain is on her way out. So, I have no doubt whether Cayman escapes the blacklist or not. I have no doubt that over the medium term, access by EU countries and therefore companies and investors who live there and do business there investments from them, the use of this jurisdiction and jurisdictions like ours by EU nations is going to fall away to almost nothing. Clearly, though, the fact that Cayman, Bermuda, or BVI, or any of the rest of us appear on the EU blacklist is not a good thing. It will have significant reputational consequences, negative consequences. And we are doing everything we can to avoid that eventuality. We are engaged, the Minister of Financial Services, myself, the Ministry, Cayman Finance, Mr. Jude Scott was over in London. He may still be there because today is only Wednesday. Appeared last night on a show hosted by Offshore Alert to defend what we do in Cayman. We are engaged with the Code of Conduct group. We are making representations. We are writing to each EU minister. We are inviting conference calls with them so that I personally, as well as the minister, can explain any, and hopefully answer any questions they may have regarding Cayman's status. As you know, we spent a week over there last month, engaged with the European Commission. We met with the Vice President of the European Commission, many others, but at the highest level, the Vice President, Mr. Valdis Dombrovskis. So we are engaged, and we will continue to fight that fight. But, Mr. Speaker, here is where I draw the line as Premier. We cannot, Mr. Speaker, make unreasonable concessions which will have the effect of making the Cayman Islands irrelevant to the very business that is the basis of our existence as a financial services jurisdiction. And so, if the choice is the blacklist or maintaining the basis of the business that we have now, we'll choose the blacklist. Cayman will survive and continue to thrive. I wonder if the European Union will. I wonder if the European Union will. So, Mr. Speaker, this is where we're at. If we have done everything that any other country in the world has done and some more than most of them, if we have, AG, how many tax information exchange agreements? 30 plus tax information exchange agreements. If we know the beneficial ownership of every entity that is registered in Cayman, which the UK can't say, and no country in Europe can say, forget about the US. If we have all of these things, if we cooperate, the AG read from the OECD report, we are substantially compliant, largely compliant, I think the term is used, with respect to every aspect that is required under the OECD rules and protocols. Mr. Speaker, what more can we do? And so, Mr. Speaker, if the OECD, I should say, Mr. Speaker, is not supportive of this blacklisting exercise that is going on by the EU, they are not. The OECD was and ought to continue to be the organization by which these tax transparency issues are dealt with and judged by. And so, Mr. Speaker, if, despite doing all of that, we are going to be put on a blacklist with countries, I'm not going to name anyone because either one because I don't want to create any international issues and embarrassment, but we know who some of the greater offenders are that simply just say, we don't care. You can do whatever you want to do. We're not going to be cooperative. We're not going to comply with any global rules with respect to transparency or anything else. But you're going to put a place like the Cayman Islands on a list with that, then I say, Mr. Speaker, that list is not credible and will be shown to be not credible. You cannot list places like the Cayman Islands and leave countries like the United States and China off. To name the two big ones who just thumb their nose at all of this. So, Mr. Speaker, we have a fight on our hands. We've always had, but right now it's heating up. And as I said, we will do everything we can through the diplomatic channels to continue to try to persuade those that make these decisions that Cayman does not belong on any such list. But I say it very publicly that as long as I'm Premier, this list and Cayman's presence on or off it will be a defining point in how we go forward in terms of continued cooperation with EU entities. Now, Mr. Speaker, the United Kingdom, it is time for her to do her duty by her territories. Because, Mr. Speaker, this requires, the blacklisting requires unanimity of all 28 EU states. The United Kingdom remains a full member with full voting rights of the European Union until the day they formally exit the European Union following the Brexit process. So if the if the UK holds out, Cayman or no other territory can be blacklisted. I wish, Mr. Speaker, for the House and the country to understand that we are doing everything on our part through the good offices of the governor and our office in the UK to engage with the UK government on this issue, with MPs who are not necessarily members of the government, as part of our efforts to persuade the UK to do its duty by its territories that have complied. For the time being, the British Virgin Islands and the Turks and Caicos Islands have been given a bligh, to use a colloquial expression, because of the hurricane. But Cayman and Bermuda are clearly in the sights of those who want to take these territories down. So, Mr. Speaker, that's where we're at. I don't think I can say anymore. I don't think I should say anymore. But you know me. Most members of this House know me fairly well. I am not one who comes with blazing guns because an idea just popped into my head. This has given me a great deal of restless, sleepless nights, and I've been through a great deal of reflection. And I have now reached that particular point in terms of my thinking. And those who also know me know that when I reach a certain point, it is very difficult to move me, save by doing the right thing. Thank you, Mr. Speaker.
If other members are going to speak on this matter, I will take a break at this point. And so I'll suspend for 15 minutes until 8 o'clock. Should I say that after such a resounding speech as was made by the Premier, you should all get up and applaud him?
We applaud him. We've been doing it.